that the Facebook Live feed is working at the moment. My name is Christopher Phillips. My pronouns are he, him, and his, and I'm an attorney at the Center for Elder Law and Justice. Through this virtual presentation today, I'm going to be talking a little bit about some unexpected events and how we can plan for those in advance. So the focus of this presentation will be on advanced planning documents for LGBT adults in particular, but also highlight sort of the importance of these documents for all individuals as well. A few matters of housekeeping before we start. This presentation is offered through Facebook Live, so there will be an opportunity for you to comment your questions or concerns in the comment box there. That will be monitored by my supervisor, Lindsay Heckler, who is also with us today. In asking questions, we just ask that you not provide any identifiable information and just ask general questions instead. The comment section will not be monitored after the presentation, the live presentation today, even though it will still be accessed on the Facebook page. So if you still have questions beyond today, please feel free to contact our main office with the information provided at the end, or an attorney of your choosing. So again, this presentation is going to be focusing on advanced planning documents for LGBT adults. And the reason that we're focusing on this particular population today is because of a new initiative launched through our agency, Center for Elder Law and Justice. Through the generous funding of the Borchard Foundation for Center on Law and Aging, we have recently launched the Silver Pride Partnership, which is a program that provides free civil legal services for older LGBTQ+ individuals. I am the attorney that directs this program under the supervision of wonderful other attorneys at our agency, and I'm very pleased to be offering this program. The clients that we serve through this program generally fall into three categories, three criteria that we look for to gauge eligibility for our services under this program. Those are some age restrictions, so 50 years old and up, some income limitations, so 200% of the federal poverty level is what we look for. And we also look for a self-identification as being part of the LGBTQ+ community. If you don't fit into one of these boxes, but you do have questions or concerns, you can always feel free to give our main office a call, and we can see if we are not able to assist you, if there is another agency or organization that is. We are very fortunate to have some wonderful community partners, including the Pride Center of Western New York, who has a spectacular social support program, Silver Pride program for older LGBTQ+ individuals. So this presentation, again, is going to focus on some advanced planning documents. So when I say advanced planning documents, these are documents that we like to see executed and in place in the event that something unexpected inevitably happens. We as attorneys typically like to see 3 different documents at a minimum, and these are the ones that we generally look for individuals to have, that are the power of attorney, the healthcare proxy, and the last will and testament. And in exploring the importance of having these documents, I think it's often wise to look to see what happens when these documents are not in place. If something unexpected happens and these documents aren't in place, what are the implications? And that can highlight oftentimes the importance of having them in advance. So to highlight the importance of these documents, I just like to pose a hypothetical situation for 2 individuals that's not based on any particular case, but is something, has elements that are frequently occurring in this realm. So I'd like you to introduce the hypothetical couple of Moira and Rose. So Moira and Rose met through a local religious community many, many years ago. And they have been in a domestic partnership for the better part of 35 years. They love each other deeply, but they are not legally married. They, growing up, did not grow up in an environment in which same-sex marriage was accepted, freely accepted as it is today. And so they are not legally married, which is, of course, perfectly fine. Rose has two children from a previous marriage. Their names are Alexis and Stan. Rose is very close with her daughter Alexis, but Rose has not spoken with her son Stan for many, many years. When Rose sort of came out and entered into this relationship with Moira, this sort of strained the relationship with Stan, her son. In terms of the property that they own, there is some co-owned property, some joint property, and also some separate property as well. So Rose co-owns a home with Moira. Rose also has some separate savings accounts, and Rose also owns a separate rental property, which we will see can potentially be an issue if something happens to one of them here. And again, we're going to assume in this hypothetical situation that there are no advanced planning documents in place. So there's no power of attorney, there's no healthcare proxy, and there's no last will and testament. Moira and Rose are perfectly healthy individuals. They're getting older in age, but they still can manage and live independently on their home. However, one day, Moira and Rose are on the way to a doctor's appointment, and they are involved in a car accident. Moira is driving and Rose is the passenger. Moira sustained some minor injuries, but unfortunately Rose experiences the unexpected. She sustains more serious injuries that result in her hospitalization, being rushed to the hospital. She's unable to communicate at the time of the accident, has some pretty serious injuries. So this is the situation that Rose and Moira find themselves in. It was unexpected. It's this freak accident, but it has happened, unfortunately. Rose is in the hospital. She's more or less incapacitated, so that means she can't really make her needs known. She can't communicate. She goes in and out of consciousness. But Moira is on the outside of the hospital. Due to COVID-19, there's perhaps restrictions on her visiting. But even if she visits, there's not a whole lot she can do to communicate with Rose at this point. So really, tragedy has struck for Moira and Rose. It is really a sad situation for them. However, the world does not stop because of this terrible, terrible accident. And so a number of issues arise as a result of this incident here. And the first issue I'd like to explore is the management of Rose's property. So as I said, Rose is incapacitated. She's in the hospital, and she can't really communicate. But she still has bills coming in. She still has that separately owned rental property and some separate bank accounts. And those bank accounts perhaps help pay for some expenses that the couple incurs along the way. At this stage, however, we find that Moira, when she tries to go to the bank or pay the bills from this separate account or manage the rental property, she finds a roadblock. Moira is not able to help Rose manage these affairs because she has no legal authority to do this. At this stage, Moira's only real option is to go to court and seek the appointment of a guardian. This process is a very long, potentially, and expensive process that oftentimes requires hiring a private attorney who charges, attorney's fees. This is a difficult situation that they find themselves in because Rose is not able to manage her own affairs right now. and there is no one who is legally authorized to transact business on Rose's behalf. Again, Moira finds herself in this difficult position, trying to help the one that she loves, a situation which is actually far more common than one would think in everyday life. So the question then becomes, what could Rose have done prior to this to have avoided this situation? Rose could have executed a power of attorney document appointing Moira or some other individual to help manage her property. A power of attorney is a document wherein a principal appoints one or more agents to help manage that principal's property. So this can include things such as banking transactions, entering into contracts, signing on behalf of a principal on those contracts, managing real property, including rental properties and things like that, personal property, and some other things as well. Unfortunately, as we found by the roadblock faced by Moira, there is no default decision maker in the event that someone becomes incapacitated. So what this means is that, Rose being incapacitated, the law is not going to come along and appoint an individual to act for her. It's going to have to be that guardianship proceeding. Again, this document requires that the individual executing the power of attorney have capacity during the execution. That's clearly not the case for Rose. Rose is not able to communicate, so Rose is clearly not able to appreciate the nature and the consequences of executing this important document. So this is something that Rose could have done in advance of this sort of freak accident to have helped her loved ones and helped herself manage her affairs in the event that something like this happened. Again, management of property is not the only issue that arises when an individual becomes incapacitated. Other issues surrounding healthcare decision making also are faced by Rose and individuals like Rose. When an individual is incapacitated in the hospital, the treating physicians and providers oftentimes look to other folks to make healthcare decisions if the underlying patient is unable to do so themselves. This is the case again for Rose. And this, with healthcare decisions as opposed to property, there is a slight difference in that there is a default decision maker for healthcare decisions. So in Rose's case, the Family Healthcare Decisions Act will likely come and operate and appoint a decision maker to manage her affairs. When there's an incapacitated individual and no healthcare agent appointed, the law will appoint an individual in accordance with this sort of hierarchy that you'll see on the screen. So they'll look first to the legal guardian. There is no legal guardian. They'll look then to the spouse or domestic partner, then to an adult child, a parent, a brother or a sister, or close friend. That is a typo there. In this case, however, for Rose, they're likely going to look to Moira because she's going to be considered the domestic partner. After 35 years, likely will be considered, even though they're not legally married. And this may seem like a fine thing. However, Rose finds herself in a dilemma in that perhaps she does not want Moira to make her medical decisions. Rose loves Moira more than anything. She trusts her with most things. But in terms of healthcare decisions, perhaps Rose does not want Moira making those decisions. She may be too close, too involved. She could very well like Moira to make those decisions for her, but she has not expressed any preferences in the past, and she cannot currently. Maybe instead, Rose would like her daughter Alexis to be making medical decisions. Maybe Alexis is a nurse or a healthcare professional or a doctor herself, and she would like Alexis to be making those decisions instead. Again, the default is going to place that responsibility likely on Moira, even if that's not what Rose would have wanted. So, you know, to avoid this dilemma, what Rose could have done is she could have appointed a healthcare agent under a healthcare proxy. So a healthcare proxy is a document that is similar to a power of attorney, in which a principal appoints one or more agents to make healthcare decisions for that principal. It can also include some specific wishes within that document. There's other documents that can be attached to the healthcare proxy, such as a living will, to express those preferences with regard to certain care. But really the healthcare proxy, the benefit of this is that you can opt out of this default decision maker hierarchy that is found in the Family Healthcare Decisions Act. Because the act is very well thought out and it's well intentioned, but it does not necessarily capture all of the dynamics that a family will face and an individual's preferences when time comes to use to look to a healthcare agent or substitute decision maker. Again, this document also requires capacity during execution. So at this stage, Rose is not able to execute this document because she cannot communicate and cannot appreciate what this document is. So this would have helped Rose had she appointed a healthcare agent, whatever her preferences would be, and perhaps have conversations with that agent about what her particular wishes were with respect to certain care. And then the final situation, is sort of the most tragic. There can be a situation where something unexpected happens, or even if it's expected, an individual's incapacity turns into their passing away. And so, this is of course very upsetting and tragic, but it is something that does unfortunately happen and something that we should think about and plan for, if possible. So say in this particular case that we are tracking, that Rose unfortunately does not sustain, she does not survive her injuries, excuse me. She does not make it through, unfortunately, and she does pass away. Of course, this is very sad for Moira and Rose's family. However, there are going to be some implications now, and it is going to sort of fall to a default estate plan. So the laws of intestate succession in New York State are going to set a default estate plan for those who pass away without a will. And this is a very simplified version of how that property is distributed. But basically what will happen is if there is a spouse and a child, they will more or less split the estate, depending on the value. They will split that estate. If there is only a spouse and no children, that spouse is going to inherit the whole of the estate. If there are children but no spouse, then the children are going to take in equal measures. If there are no children, no spouse, then it's going to go to parents. If there are no parents, no children, no spouse, it will go to siblings of the individual who passed, the decedent. Again, if there are no other relations, it's going to pass to more remote relations. So perhaps individuals such as grandparents or descendants of those grandparents, such as cousins. It can get a bit complicated depending on your family tree. So if you have questions on how your property would be distributed under the laws of intestate succession, it's probably wise to just speak with an attorney about that before setting an estate plan. But in the case of Rose, so Rose again is not legally married to Moira. They love each other. a lot, but they do not, they never got legally married, which is perfectly acceptable and fine. If the and in this case, what will happen then is that Rose's estate is going to then pass to her two children, Alexis and Stan. As I mentioned earlier, perhaps there's not a great relationship between, Rose and her children. She perhaps is very close with the one daughter, Alexis, but with the son, Stan, there's not a great relationship. And perhaps she doesn't want Stan inheriting from her property, from all that she has accumulated over a lifetime of working hard, and saving carefully. And so this is what's going to happen. Moira is, since she's not legally married, she's going to effectively be a legal stranger to Rose, which it's hard to tell at this stage, but is likely not what Rose intended or would have desired had she pulled through her injuries. And so, again, we look to how could this have been avoided? What could Rose have done to have avoided this outcome for her? And so, to do this, she could have executed a last will and testament. Last will and testament is a document that governs the distribution of property after someone passes away. So it directs where property goes to individuals, and it allows individuals to get out of this system of intestate succession. It allows them to get out of this default estate plan, which in some cases may be perfectly acceptable to individuals, but in other cases may not be. And either way is totally fine. We just want to make sure we are honoring an individual's wishes. If there had been a last will and testament, it would go through the New York Surrogates Court through a process called probate. This involves appointing a personal representative who is likely named in that document. And that personal representative, if there is a will, it's going to be an executor, an executrix, and they're going to be charged with collecting all of the property, notifying creditors, paying off debts. But they'll have some legal authority to do that through documents provided by that surrogate's court. And then ultimately, they'll have the task of distributing the property in accordance with the terms of the will. Depending on what it provides, this amount of money to this individual or this particular piece of property to that individual, they'll have the authority to do this. And so Rose really could have done these documents. She could have executed them in advance, and she could have made her wishes known, because unfortunately at this stage, there's no way of telling what she would have wanted definitively at this stage. And so the law will come in and will settle her affairs for her. One common question that I do get is who should have these documents? I think there's a common misconception that these documents are only for those who are, older adults, only seniors in effect. And I think that this conception is false and misguided. It is my belief that these documents should be executed by all individuals, all walks of life, of adult age. So this graphic I have here of children, I don't know that it's necessarily important that children have a power of attorney, nor advisable even, until they reach legal age. However, individuals of all walks of life, at any adult age really, with any assets or with any bank accounts, should really consider having these documents in place, because you never really know what life is going to throw at you. And it's really important to make your wishes known, and it's also a great stress reliever for those you love as well. If there are documents in place, it will help them to help you if you ever face a terrible and unexpected accident, for example. And it doesn't even have to come to that. If something happens where you're ill in the hospital, you can still communicate. These documents still can be of great use if you just don't have the energy. Again, it's important in deciding on individuals to help you with these affairs, to select individuals who are very trustworthy and have your best interests at heart. And so if you do decide to execute these documents, that's going to be part of the conversation with the professionals that you work with, to find out who is trustworthy in your life and who is able to really assist you at difficult times in your life. And so that's just a very brief and general overview of some of these documents. Again, it's very oversimplified. And so each individual case will have their own little nuances, and each, you know, based on what assets you have and what sort of life you lead as well. If you have additional questions, one place that I would start with is the blog on our website. So I have a link down here to a recent blog post that I have crafted for this program called Planning for the Unexpected, Which Documents Are Right for You. So that's a series of questions and answers about these documents. And it includes some more information beyond this presentation as well. So that's a great place to look as well. But another good place to look is also our agency as well. So you can feel free to contact our agency if you have any additional questions about these sort of documents or any other legal issue that you may be facing. You can call our main line at 716-853-3087. You can also visit our website at www.elderjusticeny.org. Our main offices are located in Buffalo, in downtown Buffalo. However, we do have some satellite offices in Lockport and Dunkirk, and we do serve surrounding counties as well. So on that note, I think I'm just going to see if there's any questions. I see Lindsay perhaps is monitoring the chat on Facebook. Yeah, so no questions, which is perfectly fine. Again, this presentation is going to sort of live on our Facebook page. So you can feel free to watch bits and pieces of it. If you'd like to talk with me, I'd love to speak with you about these issues and whatever else you are facing. You can feel free to call our main telephone line and simply ask for me. Our wonderful reception staff can help connect you with me. And on that note, if there are no additional questions, I just thank you for watching today, and feel free to monitor our social media as well for some upcoming presentations, not only through the Silver Pride Partnership Program, but through the wonderful other units at the Center for Elder Law and Justice. Thank you so much.